Barclays Bank filed a domain name dispute against Barclays Bank, and it won. So what am I talking about here? This is a case under the UDRP, the Uniform Domain Name Dispute Resolution Policy, and it raises an issue that I've encountered a number of times before in cases that I have filed for my clients. So first, the facts. The UDRP complaint was filed by Barclays Bank PLC, which is described in the decision as a British multinational banking and financial services company headquartered in London and one of the world's largest financial services providers. The decision also says that the bank operates in more than 50 countries and has about 48 million customers. So the dispute involved the domain name barclays-group.ltd, which was created in September 2022, more than 33 years after the Barclays trademark rights were established on which the bank, or the complainant, relied. And the decision says that the trademark is protected by numerous registrations throughout the world. So even without knowing how the domain name was being used, this seems like a pretty serious but typical case of cybersquatting. But what makes this case different than most UDRP cases, though, is that the respondent, or the registrant of the domain name, was also identified as simply Barclays Bank. In fact, the Whois record shows that the registrant organization is Barclays Bank, although the registrant name and other details are redacted for privacy. So was this a case of a trademark owner mistakenly filing a UDRP complaint against itself? I've actually seen that happen. Or against another entity that also has rights to the same name? So the UDRP has a safeguard recognizing that multiple unrelated entities can hold rights to the same trademark, a concept that's nothing new in trademark law, which requires that a registration be in connection with specific goods and services, which is why, to cite a popular example, Delta Airlines, Delta Faucet Company, and Delta Electronics can all peacefully coexist. The safeguard in the UDRP that I'm referring to is actually a defense that a domain name registrant can raise to the second element of a UDRP complaint, which requires a complainant to prove that the domain name registrant has no rights or legitimate interests in respect of the domain name. Under paragraph 4C2 of the UDRP, a respondent can demonstrate that it actually does have rights or legitimate interests if it can prove that it has been commonly known by the domain name, even if it has acquired no trademark or service mark rights. But that paragraph of the UDRP did not arise in the Barclays Bank case because the domain name registrant apparently wasn't really known as Barclays Bank, despite what the Whois record shows. Now, a cybersquatter registering a domain name using a false identity is nothing new. And that's because although domain name registration agreements require registrants to provide accurate information, cybersquatters simply ignore this, and there's little that has ever been done to enforce it. Fortunately, though, domain name panelists recognize this charade, and they don't let it prevent trademark owners from prevailing in UDRP cases simply based on the name shown in a Whois record. Specifically, in the Barclays case, the real bank said that the fake Barclays had no apparent connection to its business. And because the cybersquatter failed to submit a response, that was enough for the panel to rely on. Specifically, here's what the decision says on this issue. The use of the complainant's name, Barclays Bank, to register the disputed domain name, as evidenced by the Whois, falsely suggests affiliation with the complainant and points to an intention to confuse internet users by leading them to think that the disputed domain name belongs to the complainant or to one of the complainant's group of companies. No evidence has been adduced that the respondent has been commonly known by the disputed domain name or by the name Barclays Bank. This is consistent with plenty of other decisions under the UDRP where cybersquatters have falsely identified themselves by a name that corresponds to the relevant trademark or the trademark owner. And in those cases, for example, UDRP panelists have written that such a fake name does not alone suffice to show that the respondent is commonly known by the disputed domain name, or that it is not a believable name. So in the end, the Barclays case was indeed a pretty simple case, and the panel ordered the Barclays-group.ltd domain name transferred to the real Barclays Bank. But trademark owners should never assume anything, which is why I always like to proactively address this issue in the complaint when it arises, just to be sure that the panelist won't be confused by what can sometimes be seen as a truly confusing set of facts. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.